And Mr. Spice is charged with the offense of manslaughter in cause number 25 DCCR 0920. Mr. Macon has filed a motion asking me. Let me look at the indictment. Shows. I don't know why the heading did then and there intentionally and knowingly caused the death of an individual, namely Rowan Williams, obstruction on the bill. So at least on the indictment language, that would be murder. I know it's not, headings are not sometimes important, but I think that needs to be adjusted and changed, especially if that is what is in Odyssey. So that's showing up on everything is wrong. Yeah, so that needs to be So, based on that, it looks like the offense is actually...
Quick legal breakdown. Manslaughter means causing a death recklessly. But murder? That means the prosecution believes Ronald acted intentionally. That small shift isn't just semantics, it's a leap from a max 20-year sentence to life.
Mr. Spice and Mr. Macon has filed a motion asking that I reduce your bond. Bond is currently set. You currently set at $800,000. Mr. Macon, do you wish to call your client?
Yes.
Sir, if you'll please raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Mr. Macon.
No. Yeah. Well, you sponsor you first try to figure out. You got enough money, you were paying for the prosecution. No, sure. No. Before you were arrested, in the past you were lost stuff, right?
And here's where it gets interesting. The defense is painting Ronald as a reformed family man with a steady job and deep community ties. Classic play, he's not running anywhere, Judge. But remember, bail isn't a reward, it's a risk calculation.
In the last 2 years, in trouble, you have your wife, you have a job, you have a car, you supposed to father almost $50. Basic price sweat. You also work for exactly the whole equipment. So you're growing and working. It has the assets what the real part of the collection. You're asking for reasonable bonds and get out.
Mr. Smith, any questions?
No.
All right, any other witnesses? Mr. Smith, what is the state's position?
If there's one thing Texas takes seriously, it's violent crime involving vehicles. A life was lost here. So reducing an $800,000 bond? The judge has to weigh public safety versus the Constitution's promise, innocent until proven guilty. Stakes don't get higher than this.
$800,000 bond.
I am taking judicial notice of the court's file, which includes the probable cause affidavit, as well as there was a letter of support sent by Mr. Macon from a Rocky Johnson. Were you able to review that, Mr. Smith? I think it was emailed. Okay. Speak up, please. Alright, 2 possession of controlled. Okay. What I'm going to do is I am going to grant the motion for a bond reduction. I'm going to reduce the bond.
Bond dropped
$500,000
from $800,000 to $500,000. That's a $300,000 swing. But don't celebrate yet. GPS monitor plus house arrest equals the court's way of saying, we'll let you breathe, but only in your living room. This is mercy wrapped in strict supervision.
Sir, do you want to say that again louder? You did say something. We're going to reduce the bond to $500,000. Condition of that bond would be, if you make it, that you are on house arrest and required to wear a GPS monitoring device at all times. And we will get the case set for an announcement as quickly as possible. Right? Sir? That's what it said right now. Alright? You can go back to the item. What?
No time to
Right,
breathe.
are you looking
New
at me?
defendant, new drama. This courtroom keeps the conveyor belt moving fast. From murder to aggravated robbery in seconds. Watch how the tone flips. Different case, same justice machine.
And Carrazzo, will your client move the formal reading of the indictment of this case? Mr. Jenkins, in cause number 24, DCCR 1026, you're charged with a first-degree felony offense of aggravated robbery, and that is from March 3rd, 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you? And then, in cause number 24, DCCR 1027, you're charged with a third-degree felony offense of fraudulent use or possession of identifying information from March 12th of 2024. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? Answer out loud for me. And are you pleading guilty because you actually did what they charged you? I have here on the computer some documents in each of those cases that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Ms. Perot? And do you fully understand? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any rights? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization in the state? State tenders number 1 in each case. It's admitted in each case. Is there any evidence that Mr. Jenkins is not? Alright, sir, I'm going to find that you entered your plea of guilty in each case freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Clause number 24, DCCR 1026, finds sufficient evidence to find you guilty, and at this time, finds you guilty of aggravated robbery. Sentence you in accordance with your agreement to a term of 8 years in the institutional
8 years
division
may
of the
sound
Texas
steep,
Department of
but
the fraudulent
aggravated
use,
robbery with a
possession of
deadly
identifying
weapon?
information
That could
from
have
March
easily
12th,
meant
2024.
decades.
And how do you plead to that charge?
This is what plea deals
Again,
are
are you
about.
pleading guilty
A
freely
controlled
and
outcome
voluntarily?
instead of a courtroom gamble
You're out
where the
loud.
dice roll could
And are you
ruin your
pleading guilty
life.
because you actually did what they charged you? I have corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am making an affirmative finding of a deadly weapon in that case. And then in cause number 24, DCCR 1027, also finds sufficient evidence to find you guilty, and at this time finds you guilty of fraudulent use or possession of identifying information. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you, in each of your cases, the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment and provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Frost.
Back-to-back
Good luck,
cases,
you can go
back-to-back reality checks. One man fights for freedom before trial, the other takes a plea to avoid a worse fate. Same courtroom, two crossroads. Justice isn't one size fits all, and neither are the consequences.